Good afternoon or good morning, everybody. We are going to allow just a few moments to get everybody into our webinar, but welcome so much. We're glad to see you.
Deryn, I think we actually have a pretty big crowd this morning or today. So I think it's going to take a minute or two to have everybody come through that
The virtual door.
virtual door.
Yes. Great. Well, we want to make the most of our hour together. So welcome to everybody. At the outset, we will be posting this recording on our website. So if it does take you a minute or two to get logged on, no worries. Welcome to the latest of the Gilbert Training Group free webinar series. Today, we are going to be discussing common mistakes in raising and defending damages and remedies in EEO complaints. We're very excited to see you all. Before we get started on our program, we want to make sure everyone knows that we have a full, more in-depth training on this topic next Wednesday, October 23rd. That's going to be called Compensatory Damages and Other Remedies, and it's going to cover much more in depth all of the remedies a successful complainant can receive and the defenses and tactics agency representatives should use in order to respond to these claims for remedies. Registration is going to be closing really soon for that program, so we encourage you to register if you have not already registered. With that, Gary, do you want to introduce yourself to our folks here?
Sure. So I saw a number of names of folks that I know. So good to, I guess, virtually see those of you who I've known over the years. My name is Gary Gilbert. I'm one of the speakers today, and I guess my relevant background is I spent many years with the EEOC. Most of those as a chief administrative judge in the Baltimore district, which at the time had jurisdiction over, for a while, over Washington and also over Europe. I left the commission back in 2002 and was of counsel briefly with the law firm of Passman and Kaplan. Those of you who knew Joe Kaplan, a tremendous lawyer who recently passed away during COVID. His partner Ed Passman has joined our practice, and we're thrilled to be working with him. Left Passman and Kaplan in early 2005 and started the law firm that we have today, which has grown to be about 35 lawyers, something in that neighborhood, and I believe maybe the largest law firm that has such a presence in representing federal employees. And by the way, Deryn, we should mention that you and I both do some defense work, so we do occasionally represent federal agencies, including one of the departments and several other smaller agencies. The rest of my bio is on there, and it's thrilled to be here. I've given more than 1,000 presentations on employment discrimination matters, and looking forward to this. As you know, Deryn, there is no topic that I am more passionate about and I'm more excited about than when it comes to damages and remedies. So I'm very much looking forward to both today and our presentation in a week or so.
Thanks, Gary. My name is Deryn Sumner. I'm managing partner of Gilbert Employment Law, and I chair the firm's federal sector EEOC practice group. I have been representing federal government employees and employers, as Gary mentioned, my entire legal career. I also write some books with Gary, as well as another partner in the law firm, Shannon Leary, on the topic, and I do presentations just like this one. So since we only have an hour today, we're going to jump right in. We do encourage questions, although as Gary mentioned, we do have a large group, so we will try our best to get to everyone's question, as well as cover the materials. We ask that you use the question and answer function within the Zoom platform to submit questions. This allows us to track and make sure that we can answer as many of those questions as we can.
And Deryn, we might mention that for anyone who's planning on attending the more in-depth session we have coming up, if there are, based upon the presentation today, if there are questions or thoughts that you would like us to address in that more fulsome presentation, by all means, go ahead and let us know that, and we'll try to incorporate those thoughts into the presentation coming up.
Definitely. And so with that, we're going to turn to our program, which are the common mistakes that we see in our practice. As Gary mentioned, we represent both employees as well as agencies in the EEO process and in federal and district court. And we see the same mistakes happening both with regard to how complainants and their representatives are raising or not raising all of the claims for remedies, and the mistakes that we see from agencies in how they are responding to such claims, including what steps they are taking or not taking to gather the information they need to defend against these claims of remedies. And Gary, of course, thinking about remedies in a case shouldn't take place after you've won or lost, depending on what side you're representing. It really does need to start as early as possible, correct?
Absolutely, and I think that is a very important element in assessing a case. There are a variety of reasons to do that, including the fact that if in fact there is potential liability on the part of the employer, you do want to make sure that you approach settlement as early as possible. And you can't really do that unless you have an understanding of what the consequence would be if you were to lose the case. In addition, just the theory of the case makes a very big difference. Deryn, you've heard me say over the years any number of times that my view of civil rights litigation is it's 95% issue identification and theory of the case, and 5% actually litigating the case. Maybe it's more like 10%, but it's downhill once you figure out what it is that you need to do to prove the elements you need to prove to prevail in the case.
Right, and we always talk about the importance of planning for litigation, and key in that, you want to make sure you understand all of the claims being raised and the theories of discrimination that relate to each claim, but also the remedies are going to be different depending on what claims the complainant prevails upon. For example, the remedies available to somebody who prevails on a non-selection claim are likely going to be quite different than somebody who prevails on a claim of harassment or failure to accommodate. So we really do recommend, and this is a mistake that we see from practitioners on both sides, is not taking the time to sit down and not only think through the legal burdens, but also the available remedies, and making sure that you understand what remedies would be available depending on the types of claims raised and prevailed upon ultimately. And of course, Gary, how do we gather that information that we need to be able to present both sides? Discovery.
Obviously, discovery is the place to get it. And I will say the common mistakes we put together are not necessarily in the order of importance, but I'm going to highlight this one because I do think the first edition, Deryn and I co-author a textbook on compensatory damages, and other remedies in federal sector employment discrimination cases, a text that I initially wrote back in, I think, 2002, and Deryn has been a co-author with me almost ever since. But in the first edition, I talked about the fact that remedies is often an afterthought to litigation. And I told the story in that case about a case that actually came out of the Seventh Circuit. And it was a case in which the Court of Appeals memorialized the entirety of the presentation of damages by the plaintiff as follows. During trial, question, and when you were fired, how did you feel? Answer, bad. Question, how bad? Really bad. No, not to be undone, the defense counsel couldn't leave well enough alone and had to revisit the issue on cross-examination by this question. And again, this is the totality of evidence in the record. Question, on direct examination, you testified that you felt really bad. You really didn't feel that bad, did you? And that was the entirety of the damages. And on appeal, the plaintiff was seeking additional damages, which at the bench trial had been awarded by the court. And the court, not surprisingly, made somewhat lighthearted comments about the quality of the presentation. But I think it does show the fact that oftentimes we spend so much energy preparing for hearings or trials about liability that we really don't do the things we need to do to prepare. And in this area, when we're talking about common mistakes about just planning for discovery, oftentimes we don't know at the outset of discovery, we don't know what the true liability or litigation risk might be for those of you who defend government agencies or defend any entity. And therefore, the case may look like a very strong, nearly slam dunk case, and we don't think to ourselves, well, there's no real chance. I'm going to do discovery for the purpose of bolstering a motion for summary judgment. And then something goes terribly wrong, and you lose the case, and you have no idea what the presentation on damages is going to be in the case. And that's a worst nightmare, is that you are going to be on the hook for not just $300,000 in compensatory damages, the statutory cap for large employers, of which the federal government, generally speaking, is, but for all kinds of damages, back pay, potentially front pay, promotions, interim promotions, the compensatory damages, but pecuniary compensatory damages. Someone who lost their home and had to sell it and may have suffered hundreds of thousands of dollars in pecuniary damages, which are not subject to the statutory caps, something we're going to discuss in some detail at our upcoming seminar. But for all those reasons, planning out discovery and asking all plausible questions, and I believe we may touch on this a little bit later in today's discussion, Deryn, but one of the key things to realize is that when it comes to damages, there has to be, of course, a causal relationship between the loss, the damage, and the employer's misconduct. And oftentimes, there may be other mitigating factors that come into play on damages, such as other causes of emotional harm. And those kinds of things need to be asked in discovery at the outset.
Yes, although the regulations state that the agency should conduct an appropriate investigation such that there could be a finding of discrimination as well as an award of remedies, the reality is that reports of investigation rarely have sufficient information to evaluate the damages and the remedies that a successful complainant could receive if they do prevail. We also have experienced, and I know many of you out in the audience have as well, that administrative judges, when they are convening initial status conferences, and this experience does vary, but some judges are requiring quite a specific articulation of what is needed in discovery before they will even authorize the parties to engage in discovery. And so we do really recommend that you plan ahead and have at least a bullet point list, if not your discovery requests already drafted, in advance of the initial status conference. And oftentimes you will need to supplement the record on damages, as we'll talk about in detail about what exactly you want to be asking for, but making sure that you are planning ahead and that you are prepared to articulate to the judge what exactly you are going to need from the complainant in discovery. Also, for those of you who represent complainants, sometimes you're going to need some information, leave records, for example, information about comparators' overtime usage, if you have such a claim. So you do want to be thinking through what information you may need as a complainant or complainant's representative to ask for the agency to help support a claim for damages or other remedies.
But our discussion of planning for discovery flows very nicely into the next common mistake, which is a failure to factor in or consider efforts to mitigate back pay. And I mentioned mitigation of compensatory damages a moment ago, which is, by the way, when we use mitigation of back pay as a term of art, there is no obligation to mitigate compensatory damages that has been routinely established by courts or by the commission. There is a requirement with regard to mitigation of back pay, and that's something that exists even in tort law when we talk about lawsuits that impact compensation from pay. So understand that the victim or the alleged victim of employment discrimination is required to mitigate back pay. And you can see this on the slide. This means that what you need to do is to seek for other alternative comparable employment. If you're a lawyer, you don't have to apply for a job at a McDonald's. If you do, by the way, and you work at a McDonald's, that's an offset. It may not be much of an offset to the lost earnings, but it is an offset. So any employment that you take other than moonlighting employment would serve as an offset. But the obligation to seek alternative employment is for comparable employment. Now, one of the mistakes that I think is commonly made is not exploring whether the employee has engaged in or fulfilled their duty to mitigate back pay. And we tend to take, those of us in the profession tend to take on its face efforts to mitigate back pay. So someone's fired from their job. We check to see whether they've done something to search for other employment. They've done that. Maybe they've done that aggressively over some period of time. That's not where the conversation starts, because it's an ongoing obligation to seek to mitigate back pay. And therefore, even if a discharged employee diligently looks for other employment for some period of time, if they do something that removes themselves from the workplace, that is being ready, willing, and able to work, that would cut off or create a hiatus in any entitlement to back pay. So if during the course of that, they at some point in time care for an ill parent, return to an educational facility full time to enhance their education requirements, that may not cut off back pay, but it might. It's a factor to be considered. Something we'll go into again in more detail for those of you who will be joining us for the upcoming seminar. But how do you know whether an employee has done what they are required to do? Generally speaking, there's just one way to do that, and that's through discovery, through interrogatories or through depositions. Personally, I think it plays better, a better way of developing the record for a failure to mitigate through deposition. But either way, it's something that has to be on your radar and plan for discovery. Deryn?
Definitely, and document requests, I think, are key as well, because you want documentation of the employee's efforts to try to find employment. And it is very powerful if you ask specifically for that information and the responses, I have no documents. So I agree, all aspects of interrogatories, document requests, as well as deposition. So we want to make sure that we are thinking through that. And again, that's only going to apply in circumstances where there is in fact the loss of back pay. So that's why planning from the outset is so important. And Gary, you kind of touched on this on the prior comments, but of course there are claims that we want to make sure for non-pecuniary compensatory damages that we're thinking through circumstances that could serve to limit awards. And you mentioned specifically, lack of nexus between the agency's actions and the harm. But of course, there are several circumstances that practitioners want to make sure they're thinking through in response to claims by complainants for non-pecuniary compensatory damages. And you're on mute, Gary.
My apologies. Well, there's a train that comes by every day at this time, and I don't know if you could hear it or not, but the conductor likes to toot that horn with some frequency, so I put it on mute. So yes, again, I think as you're pointing out, there's a frequent failure to explore these, and all of them have to be explored through discovery. Well, possibly with the exception of the good faith defense, which is solely within the control of the employer. The good faith defense, of course, being that you made reasonable efforts to provide an accommodation, reasonable, the statutory language is you made reasonable and good faith efforts to provide an accommodation, in which case you don't lose, it doesn't affect liability, but it does affect damages because there's no compensatory damages. But all the other ones are mitigate any losses of pecuniary damages, doesn't necessarily exclude someone from receiving non-pecuniary damages, but it may dramatically reduce those. And in fact, a lack of nexus would eliminate whatever the claim for non-pecuniary damages happens to be. For example, a claim for damage to professional reputation or loss of professional standing. If in fact there's a lack of nexus, there would be no compensatory damages because of that. And that is probably one of the more, these days, probably one of the more higher ticket items in terms of what courts or what the commission award for non-pecuniary compensatory damages. Very important. Again, all of this ties together in a common thread, and that is discovery.
Right, so we want to be thinking through how, when we ask complaints to identify how they have been harmed. And oftentimes it's hard for complaints to articulate or link exactly what has happened to them and that it's because of the agency's actions. And some of these situations are easier than others. We see cases from the commission where somebody details substantial financial harm that they have experienced, but it turns out that there is a lack of nexus between what the agency did, which is perhaps a claim of non-promotion versus somebody who subsequently loses their job. That's going to be an intervening cause. If it's not raised as part of the EEO complaint, then subsequent financial harm because of that loss of income is going to demonstrate a lack of nexus. So agencies, you want to make sure that you understand the limits of which the accepted issues are, and making sure that there is a clear argument for there being a lack of nexus. It's very easy for complaints to identify, this is everything that's horrible in my life, which is all well and good, but you still have to, in order to receive compensation from agencies, be able to link it to something that the agency, of course, did. Similarly, in terms of the other bullet points we have here, pre-existing medical conditions. Agencies would only be responsible for the exacerbation of pre-existing conditions because of the agency's actions. If somebody has been diagnosed with depression since 2005, and then there is an act that takes place in 2022 that the agency is found to be responsible for, and the complainant says, well, I experienced depression because of that, you do need to explore what, this pre-existing condition, when was it diagnosed? Because the agency is only going to be responsible for the increase in suffering of symptoms that it can be temporally related to the agency's responsibility. Of course, it's not responsible for all of those years of harm because of the pre-existing condition. And we see this both with physical and mental medical conditions. And as Gary mentioned, this is so important. We complaints are not going to volunteer this information. We do need to make sure that we are requesting it in discovery. Gary?
Yeah, and Deryn, this relates not only to, as we pointed out on the slide, non-pecuniary damages, but there also may be a secondary implication for any claim for pecuniary losses. Just as an example, as you were just mentioning, that someone may have had a pre-existing psychiatric or emotional issue for which they've been having therapy or psychiatric care over an extended period of time, and they may be asserting that condition, the anxiety disorder, the psychiatric disorder, whatever it might be, was causally related to the discrimination. But if it's found that it is not related, then not only do they not get compensatory damages with regard to that element, but they also can't recover the physician fees or the healthcare costs related to that. Bear in mind that if sometimes it's sort of a split the baby when we talk about pre-existing conditions, because it may well be that somebody was seeing a therapist perhaps once a month. And then as a result of an act of discrimination, the employee's pre-existing medical condition was exacerbated on the discrimination. And then as a result, they were seeing a therapist every week, approximately 4 times a month. Under those circumstances, they might be certainly entitled to some compensatory damages for the exacerbation of the medical condition in terms of non-pecuniary damages, but they also be entitled to the additional costs of medical care that they incurred as a result. And in this case, the example we're using, you have 3 additional sessions that would be covered. And it may be, this is where it's really important to understand that when the Civil Rights Act amendments were passed in 1991, and compensatory damages were available for the first time, a statutory cap of $300,000. $300,000 was a lot of money. And not that it's not still a significant amount of money, but it pales by comparison. In 1991, in today's dollars, it's less, the value of a $300,000 award is less than the value of $150,000 in 1991. So pecuniary damages, which are unaffected by inflation because there's no statutory cap on pecuniary damages, they have become, in some ways, a potential higher area of liability for employers than the non-pecuniary compensatory damages. And somebody who, as a result of this, has testimony that shows that they've increased, in the example I gave, from once a month to once a week. If there's a presentation of evidence where the healthcare provider testifies that, in their professional opinion, the person will need to continue receiving therapy for an extended period of time, 5 years, maybe 10 years, or indefinitely, the value of the medical care may be enormous. And indeed, Deryn, we steered away from case citations today, but there was a recent commission case in which the issue of the value of the healthcare services as opposed to the copay. Do you recall what the numbers were involved in that case?
I don't.
So it was something, if I remember correctly, it was in the hundreds of thousands of dollars. And the commission held, we're going to talk about this again in the upcoming seminar for those of you who will be with us. The commission held that under the facts of that case, the employee was entitled to the full value of the healthcare provided, which was the hundreds of thousands of dollars. If I remember correctly, I think it was $600,000 or $800,000, rather than the copay, which was several $1,000s. And that just shows you the importance of making sure that you develop the case. Those of you who are defending the agency, develop the case in an appropriate fashion.
Right. Similar to pre-existing conditions, of course, most of us do not lead nice, neat lives where the only thing that happens to be going on is an employment dispute that is causing us stress and harm. We have family issues. We have our own health issues. We have stress about any number of things. We're dealing with everything on a day-to-day basis outside of the harm caused by our employer. And that, quite reasonably, agencies should serve as an argument to an administrative judge or other fact finder that not all the harm claimed by a complainant is directly attributable to the agency's actions. And you're only going to find out about what else might be going on in an employee's life if you ask those questions during discovery. And I think the most effective means of doing this is through deposition questioning, asking, okay, well, during this time frame, were you experiencing anything else, elder care, concerns about your kids, financial stressors, anything else that reasonably could have caused stress and anxiety and worry for an employee during that same period of time, is going to serve as the basis for a nice argument to a judge that 100% of the harm is not directly related to the agency's actions, and therefore an award should be reduced commensurate with that. And we briefly touched on another way to limit is the good faith defense in a reasonable accommodation claim. If an employer can show that it attempted in good faith to try to provide an effective accommodation to an employee, even if ultimately it did not provide an effective accommodation, then that can be a defense raised to not just limit, but in fact reduce any liability on behalf of the agency for non-pecuniary compensatory damages.
And here's an area where I think we can't stress strongly enough the importance of documenting the efforts that were made. If you're going to present to the judge, or court, or whoever the trier of fact is, evidence that the agency engaged in good faith efforts to provide reasonable accommodation. Just as an example, if the accommodation of last resort, which is a reassignment, if there's evidence that the employee could no longer perform the essential functions of their job, and the employer must consider alternative employment, oftentimes the question of liability as well as damages may rest upon the question of whether the employer did a fulsome effort to seek alternative employment. And having an HR person or having a series of individuals from the agency testify about what they did to seek alternatives, if it lacks a degree of specificity, doesn't matter how much they say, I made a lot of phone calls, I looked at all the possible jobs, you want to present evidence of what specifically, who they talked to, what efforts they made, what vacant funded positions were identified, if there were vacant funded positions that the employee didn't qualify, why didn't they qualify for the position? A general conclusory statement saying, as we looked and we identified a half a dozen jobs in which the employee had the requisite requirements but didn't have the experience, that's not going to meet your burden because it's conclusory. It doesn't show why they didn't meet the requirements. So just bear that in mind.
Right, and so we're going to talk a little bit more in detail. Obviously, we mentioned the importance of exploring damages in discovery. But we do want to emphasize the importance of that. We want to make sure that we are crafting interrogatories, document requests, deposition questions to make sure that we have the ability, if we're representing the agency, to be able to articulate, okay, what is the complainant actually seeking in terms of remedies, and what evidence do they have in support of that? Who is going to be testifying at a hearing in support of the harm that they are claiming to have experienced? What evidence do they have of pecuniary damages? We want to make sure that we are asking for a copy of those invoices, bills, other things that are being claimed, so that we are not caught at the first time through receiving a pre-hearing statement or otherwise seeing exhibits attempted to be presented for the first time at a hearing where we haven't had the opportunity to both receive them as well as question the complainant on what exactly the expense is and what evidence they have of that nexus between the agency's harm and the claimed expense. Also, it's really important to know who has witnessed the alleged harm. And this is going back to the responsibilities of complainants representatives. This is also something that's really key and needs to be explored early with your client is, gathering information from them so that we can make an assessment of likely awards, because we don't want to have a client who ultimately prevails and because they didn't have that evidence or because we didn't have a fulsome presentation of evidence does not get much in the way of remedies. As we know, damages awards can be as little as $500, $750 for more minor claims of harm. And in order to get those higher awards, you are looking at a presentation of damages that does include, if not just the complainant, their partner, family members, neighbors, coworkers, anybody who can say, this is who this employee was, and then I witnessed firsthand how they were changed during the time frame that matches up with the harm at issue. Also, medical care providers. I can say from firsthand experience in representing complainants, it takes a while to get doctors' offices to respond to our requests for medical records and information. And so if you are representing an employee, you want to make sure that you are having them request those records or giving your office authorization to request those records on the earlier side, because it can take a while to get their attention and get those medical records in your possession so that you have them ready to assess what your client is likely to get if they win, as well as being prepared to respond to discovery, because all of our agency reps out there are going to make sure that they are asking for it so that they know what medical records are going to be presented at hearing.
And not just medical records, Deryn, but other evidence as well. Just as an example of what we're talking about here is just a case that I co-counseled with Josh Bowers some years ago. Josh Bowers is a very talented plaintiff's lawyer who has since retired. But the government, this is against a DOD agency, and the government never asked some of the important questions in discovery. And one of the key elements is we had made a claim that our client suffered significant hair loss. It was a woman who had been very proud of her hair. It was quite an issue with her pride in her grooming that went back many years. And we asserted that she began to lose hair because of the harassment that she was being subjected to. It was a sexual harassment case. The government never made any efforts to determine what evidence that we had with regard to that, assuming it was going to be her own testimony, but it wasn't. And in fact, when this finally came up in the 11th hour, the government actually settled this case. This is one of two reasons why I believe they settled the case. But the testimony, the evidence we actually had was not our client. We had a beautician that she had been going to for many, many, many years, who told her one day, "You're losing your hair. Your hair is coming out." And that's how our client first became aware that she was suffering hair loss. Agents had never asked what witnesses we're going to be calling in discovery. They never took the client's deposition, so I had no idea that there was going to be compelling evidence that this conversation took place between the beautician and the client shortly after she filed a complaint of discrimination, alleging that she had been subjected to sexual harassment. So that type of evidence can be very important. So too can be social media, which is not to be underestimated today and can be exceptionally valuable. People who make a representation that they've that as a result of the discrimination, we sometimes hear the argument that the impact on them has been that they've lost enjoyment of life. They no longer enjoy doing things with their family, things of that nature. Social media might provide evidence that is quite contradictory to that. Fair to say, Deryn?
Yes, and actually, I think that's a great segue to an exciting announcement we have about the latest edition of the book that we author on this topic, Compensatory Damages and Other Remedies in Federal Sector EEO Complaints. We have been able to obtain a number of decisions issued by administrative judges, and those are not available on any of the Lexis, Westlaw, Cyberfed's websites. And so we have a brand new chapter in this latest edition that summarizes, and we'll be adding to it with each edition as we're getting more and more of these decisions. And there was a really interesting decision from an administrative judge where the complainant had asserted just what Gary was saying, that he had lost enjoyment of life, he didn't enjoy hanging out with his family, and complainant was faced with a bit of a pickle when agency counsel sought to introduce the YouTube channel that the complainant had with his family that showed him hanging out by the pool, enjoying life. And she or he sought to question the complainant about these videos. Interestingly enough, the videos happened to disappear during the course of the hearing, and despite a direct order from the administrative judge to the complainant to restore those videos, they were not restored, and as a result, the administrative judge found that the complainant was not credible regarding the testimony, and the complainant only received $5,000 in compensatory damages. So that decision, along with several dozen others, are summarized in our latest edition of the Compensatory Damages book, which is available through Dewey Publications. Gary, we have a question here. Is it proper to ask for not only copies of bills, but also for evidence that the bill was paid? And is the agency on the hook for paying a damage if the complainant did not actually pay it? For example, did they actually suffer any harm? Unless, of course, the question asks if the bill ultimately goes to collections.
Yeah, I think that's a very astute question. And the answer is going to be a bit of it depends. Probably that the complainant will be entitled to compensation for it because the question is, do they have a legal obligation to pay it? Whether they pay it or they don't pay it is not something that the agency can use as a defense. The question is, do they have a legal obligation to actually pay the bill? So that if they receive health care and the healthcare provider is a family friend and doesn't charge them, and there's probably no legal obligation to pay the bill. But in most instances, if they've been paid, you don't have to wait until it goes to a collection agency. In fact, there's a case that goes way back, one of the first cases in compensatory damages after the statute was passed, the Mack versus VA case, in which there was some testimony by the complainant about their both failure to seek healthcare and whether they incurred actual costs in what little healthcare they did. And the testimony, which was referenced by the commission in the appeal, was something to the following, which is that I would have liked nothing more than to be able to continue to get healthcare and to pay my bills. I couldn't do that because you took my job away from me when you fired me. And so I think that really sums up the issue. If there's some reason to believe it's disingenuous and the person is not actually intending to pay the bills, that may be different. But generally speaking, that is not going to be a persuasive argument. Deryn, you disagree?
No, I fully agree. I think those collection companies will ultimately find the complainant. So they do have a legal obligation to cover it, even if they have not paid it as of your inquiry. So as we've mentioned, you want to think through interrogatories, document requests, and depositions, not only of the complainant, but it may be a case if you're looking at a particularly complex claim for damages with a potential high value, you may seek to depose medical care providers as well as those identified witnesses, families, coworkers, family member, coworkers, friends, who may be called to testify at a hearing, so that you are not caught off guard as to what they will testify about once you get to the hearing stage.
Just picking one example of how important interrogatories may be. And one of the common and legitimate claims of non-pecuniary compensatory damages is damage to during marriage, or damage to a long-standing personal relationship. And I mean, certainly that is a consequence. Oftentimes people become unbearable to live with when they're suffering discrimination or harassment in the workplace, or when the family is undergoing financial strain because of it. But that's not always the reason why there's marital strain. And when you're asking interrogatories, you've got to explore those. It is not a comfortable question to ask whether there has been ongoing difficulty in the marriage, whether they've ever had marriage counseling in the past, whether either of the individuals in the marriage relationship have had affairs outside of the marriage. But all those are relevant to the question of what caused the damage to the marital relationship or the personal relationship. Just as an example, the kinds of things that those questions, by the way, are on my standard list of things that I ask. Very difficult to ask them. Very uncomfortable, I should say. It's not difficult to ask. It's uncomfortable. But you got to do what you got to do when you're doing these questions.
I agree, and when you are representing a complainant, you want to make sure that they are prepared for the possibility when they are sitting for a deposition, or when they are, understanding the full. I'm going to use the word intrusive nature of discovery in these cases, so that your client, has been counseled and is aware, hey, you know what, they can ask me these questions. I'm happy to, put on my agency counsel hat and give you a flavor of what to expect. And one of the things we always say here is when we prepare our clients for testifying, we want to make sure that it was actually more painful going through the preparation process with us, pretending to be opposing counsel versus what the actual experience is. So we will sit down with our clients and say, hey, we're going to ask the difficult questions about, your personal relationships, your health, your family members' health, so that you're not going to be caught off guard if agency counsel asks you those questions.
And it doesn't apply. It doesn't apply just to, by the way, to those representing a plaintiff. I agree that that is incumbent upon representation, because for plaintiffs, one of the worst nightmare scenarios is when the deposition's over and the client calls you up on the phone and says, "I need to tell you something." That's never a good sign. And what I need to tell you is they asked me if I ever had a relationship with anybody that I work with, and I said no, but I really did, and I didn't know what to do because I didn't want to tell them. That's the worst case scenario. But what Deryn's saying is the same thing in terms of when we're preparing a management employee, when we're representing a government agency, and that is that when their deposition is over, I want them to tell us that our prep session, in which I actually do that. I think Deryn does too. I actually act as opposing counsel, and I ask them the most difficult questions I can imagine, and I expect them to walk out of the deposition saying, "Wow, that wasn't nearly as bad as the examination you did with me. Another really interesting question, Deryn, no?
Yes. So Gary, we have a question here. Can you speak a little as to how these suggestions would apply when an agency has their FAD overturned by the EEOC and is ordered to produce a compensatory damages final agency decision? And so that is, because there's not discovery available, there is not going to be the ability to take these depositions. However, agencies can engage in an investigation, request affidavits, supporting documentation. And so you do want to make sure that you are fully explaining to complainants, especially if they are proceeding pro se, of what exactly you are requesting in support of of the agency's obligation to investigate and issue a FAD on damages, so that they don't appeal to the commission and the commission says you didn't fully explain the process and give the complainant an opportunity to present all evidence of damages. But that is because of the procedural nature. It is not going to be as fulsome of an exercise because there's not discovery.
And let me say, I believe it's inherently unfair to agencies that a complainant can ask for a hearing and the agency cannot. So you're stuck in a sort of a catch-22, as the expression goes. But note what Deryn just said, which is it's not that the agency is ordered to produce a FAD. They're ordered to conduct an investigation and issue a FAD. You cannot have an advocate do the investigation. It has to be somebody neutral, but they should do a full inquiry into it, and that should include those questions that are appropriate to ask about other causes of emotional harm. And we do have a question, Deryn, whether the slide I see from a good friend and colleague over the years, asking if the slides are going to be available.
We are going to be posting the recording of the session on our website. So that the slides will be available through that recording.
Right.
So
15 minutes left here.
Document requests. So of course we want to make sure that we are requesting medical records. However, if the complainant is not represented, agencies, please make sure that you are following the revised MD 110 Chapter 7, which was revised in 2015 and does require agencies to request permission from the administrative judge before making such requests of unrepresented complainants. I've been in a few initial status conferences in the past few weeks where judges have done a really nice job of explaining the requirements of MD 110. So that's always wonderful to see. And so make sure if the complainant is pro se, that you are running those requests by the administrative judge. Easiest way to do that is just to be prepared at the ISC with that request. As Gary mentioned, it's not just medical records. Has the complainant kept journals, diaries? Do they have calendars that show when they are, attending EAP sessions or therapy? Or other things that they have changed about their lives because of what they're claiming is the agency's harm, that might be reflected in a personal calendar or other document that they are keeping, that they're contemporaneously recording what's going on, as well as, of course, those invoices, because to get a pecuniary damage, you are going to need an invoice, a proof of an incurred expense, unlike non-pecuniary damages, which can be awarded simply on the complainant's testimony of the harm suffered.
And just a quick sidebar on this is if the complainant or counsel on their behalf asks for a protective order, provide it. That's I always ask for a protective order before providing medical information, just so it limits the dissemination of the information.
And we have a question: how do you serve those discovery requests by the deadline, asking for medical information and also request permission from the judge? So typically the deadline to initiate discovery is going to be set at the initial status conference. And we do recommend that you come prepared at that initial status conference with what you would be seeking to get in discovery. And so I would be prepared to make the request at that time. Your Honor, we will be seeking to engage in discovery in this matter. Because the complainant is pro se, pursuant to MD 110 Chapter 7, we are seeking your permission to make that request for medical records. And then the deadline to initiate discovery is usually going to be after the judge authorizes discovery at that initial status conference.
And by the way, the second bullet, life events that may have caused, I think it's good practice to identify examples such as, have you been involved in any car accidents? Have you had bankruptcy, foreclosures, financial difficulties, late payments on credit card debt, virtually anything that would indicate other sources of emotional harm. We have a couple of really interesting, this is a good audience, Deryn, some really astute questions. Do we have time to grab a couple of those?
Sure. So can you speak to the tactic of seeking tax documents to verify assertions made by complainants regarding financial harm suffered? So again, MD 110 Chapter 7 has been revised to limit what tax documents can be requested from complainants. So I do recommend that you take a look at that, because it is going to say that requests for tax, W-2s and things like that do need to be limited to the exact claim at issue, which is typically loss of back pay. Anything to add on that, Gary?
Yeah, there are limited circumstances in which it is appropriate, but as Deryn said, we don't have the time to go into it now. Maybe we will at the next session, but look at the guidance.
And so, Gary, one thing that I think, especially compliance counsel, don't think through enough is considering requesting the restoration of leave as a remedy, because it can be quite substantial and can be quite a financial benefit to the complainant if they are able to get leave restored. Again, they do have to show that the leave was taken because of the agency's actions. I just couldn't bear to go into work on Mondays because I was sick all weekend because of the harassment I was experiencing from my supervisor. If true, then the complainant can get that leave restored as a remedy. And so we do want to make sure that we are asking those questions in discovery. And we want to make sure that the complainant has evidence that they did in fact take all of the leave that they're claiming was because of the actions because of that, and not because they, took the family to Disney, or they were suffering from the flu, or any other reason that might be unrelated to the harm that has been proven.
And bear in mind that it's the employee has the burden of proof to show a causal relationship between harm and the employer's misconduct. And by the way, Deryn, in response to a question, I believe the only version of the MD 110 that's on the commission's website right now is the current one.
Yes, Torrin has provided the link, and it was updated in 2015, I believe August 2015. Gary, you've talked about this throughout our conversation about compensatory damages, but as you've mentioned, pecuniary damages can be quite substantial, and they are not subject to the $300,000 cap. So forgetting about them at either the complainant's point of view or the agency's point of view can be at your peril, because it can be quite a substantial recovery for the complainant.
I happen to have a copy of the textbook in front of me, Deryn. The past, there are two types of pecuniary damages, past and future. The future pecuniary damages are limited to the statutory caps because there's a degree of speculation involved. Past, no statutory cap. Had a case some years ago. My client had a house he bought for a couple $100,000, happened to be in central San Francisco. He had to sell his house as a result of discrimination. The case took 12 years to fruition, and in the end, he sought and was awarded the value of the house. It was a settlement, so I can't tell you about the settlement, but I can tell you that the house had increased in value by $1.2 million during the time period, those ensuing 12 years. They can be very expensive, and it's really important that you challenge the evidence to show a causal relationship. Just as an example, somebody who was applying for jobs elsewhere in the country and as a result of being discharged, sold their house. It sounds like they were going to sell their house anyway. So the loss of the value of the house may not be an issue, just as an example.
Speaking of expensive, and Gary, we do have at least one citation on our slides today, because I think it so powerfully illustrates this point. An individual who receives back pay as a lump sum payment can present evidence of the tax consequences as a result of receiving that back pay in a single tax year, as opposed to having received the income in each calendar year. And it can be quite substantial. And this is actually a case where we represented the complainant, where in addition to the back pay award that the complainant received, the commission earlier this year awarded an additional payment to the complainant of $296,000 just for the increased tax burden that the complainant experienced because of the back pay award.
And Deryn, one of the things we're going to talk about is what evidence at the next seminar is what evidence the employer can present to try to mitigate or limit the consequences of increased tax burdens. Because I'll tell you, I have never seen, not once have I seen an agency mount a viable defense or effort to mitigate the evidence we've presented in a case involving a tax gross up that is offset for increased tax liability. So just a couple, if I can just grab one of the questions that's on here. Can pecuniary damages be awarded solely based on complainant's testimony? It can be, but it won't be if you do your discovery well. If you, generally speaking, there should be evidence of bills and receipts for virtually all past pecuniary damages, and there should be written estimates, documentation about future pecuniary damages. However, if testimony is unrebutted, judge can rely upon it.
And our last common mistake, I decided to round it out with a nice even 10, responding to fee petitions. So of course, if the complainant prevails on a claim before the EEOC, except if it is a claim of age discrimination under the ADEA, he or she is going to be entitled to a reasonable amount of documented attorney's fees. When we are responding to those fee petitions, we have some tips for you. If they are a prevailing party and the statute allows for recovery, don't argue that the attorney should not receive any payment. That's not going to fly. Check your math, check the complainant's attorney's math. Many of us went to law school because we're not good at math, but of course, many of us have very talented folks assisting us in preparing those fee petitions who are a bit better at it, but mistakes happen. So make sure that you are checking and making sure that what's being represented as the lodestar for fees is in fact accurate.
And Deryn,
when you're
I was just going to say that we devoted 75 pages in a text, and the text is almost too small. I mean, I have to squint to look at the complexity of legal fees and what both sides can do to maximize or limit legal fees is very, and this is a big, we have a petition, I have a petition pending in a case in which the legal fees were over $1 million in an individual case. So they can be a lot of money. It's important to do this. Go ahead. I didn't mean to interrupt you, Deryn.
No, it's fine. When you are reviewing the billing history as presented by complaints counsel, some things to look for. Are the billing entries being claimed unrelated to the issues that have been prevailed upon, or perhaps assisting the employee with something outside of litigation before the EEOC? Is the time spent on a task, in your view and the commission's view based on case law, reasonable, not reasonable? Does it match up with the times that are reflected on deposition transcripts, hearings, etc.? And you may want to argue for an across-the-board reduction as opposed to going line by line.
And we had one last question, Deryn, from another very talented and long-term colleague of ours, about whether or not if somebody is loses their job and is out of money and they apply for Social Security benefits, whether that somehow helps in the mitigation. And the answer is no. We're going to talk again at the next seminar about the collateral source rule, but Social Security benefits are always collateral source, and therefore they do not offset the employer's liability.
Yeah. So as a reminder, registration will be closing soon on our longer, more in-depth training on this topic. Obviously, we could only skim the surface of all of the issues raised by compensatory damages and other remedies. But you're in luck. We will be devoting a full day to this next Wednesday, October 23rd. We also have some exciting programs as we finish out our fall programming. including absence and leave issues with Barbara Haga and bargaining by the numbers presented by Frank Ferris. We do thank you so much for your attendance and the wonderful questions today. If you have any additional questions or you want to make sure that you're on our mailing list, please reach out to gilbertttraininggroup@gelawyer.com. A survey is going to pop up as you exit. We very much would appreciate if you could take the time to respond to that survey. And thank you so much. We hope to see you again at a future Gilbert Training Group program.
And Deryn, let me just quickly mention that we also have available on-site training that we do in conjunction with LRP, the cyber feds and FDR folks. And so if there's any topics that you would like presentations on together with LRP, we're available to do them. Thanks very much. Always fun to present with you, Deryn.
Thanks so much, everybody. Bye-bye.